Option, yini komo o channel so AGH politics albany. Fast forward, Yamura Ken Ofori Ata Asway, na Unia OXP, a ruling a US immigration judge at the bar, Abonten so, all sign Ken Ofori Ata, eti se, in Tassa, Yadi Abono, Sabia Sonsi Benyado, the Moha. Na eno sheda omu sheda any concrete charges be a beat me a free a year omu mining a US or edinaba a year Ghana haxi na o say na a year OSP and so etimi ababontin so abetre say and sama omu kano onyin tum o biaso na ken ofori ata still we obia say yade intasa bon say odwani afri mra ho a your friend say ye fugitive no still sa charge mo unia ebuso eda no so a unia mesro say lawyer Martin Pebu ademre abra oboyi nchimu efasa insemusi ensemre emunram na yehwede ko odede ba
case regarding Ken Ofori-Atta. We published it earlier today on 3news.com. And that is what has gotten some reaction. The Office of Special Prosecutor has reacted to this, but just for the uninitiated, I want to tell you what David Gade, who is the immigration judge in the United States Immigration Court, said regarding Ken Ofori-Atta and the matters against him. He says the OSP affidavit is full of conclusory allegations without any description of credible or reliable facts that would indicate any form of criminal wrongdoing by the respondent. So essentially just about allegations without any fact. That's what the judge is saying. It goes on to say that the lack of persuasive evidence indicating any form of criminal wrongdoing or criminal conspiracy involving the respondent in the OSP's affidavit is powerful evidence. That's the lack of persuasive evidence indicating any form of criminal wrongdoing or criminal conspiracy involving Ken Ofori-Atta. Even in the OSP's own affidavit, according to the judge, he says it's powerful evidence. There was also no evidence that the respondent personally profited from anything he did as Minister of Finance or as a government official. This portion of the transcript, or these two, this one and this, is what has got a lot of people talking as to exactly whether or not this charges against Ken Ofori-Atta by the special prosecutor would hold. Well, the Office of the Special Prosecutor put out this statement that they have taken note of the transcript of hearing purportedly emanating from an immigration court in the United States involving Ken Ofori-Atta, which is being circulated by some media houses, suggesting that Ofori-Atta has not been credibly charged in Ghana or credibly shown to have engaged in any wrongdoing in Ghana. The OSP stated on 16 June 2026 that it is not involved in immigration hearings in the United States involving Ken Ofori-Atta, and that the OSP's involvement relates to extradition proceedings against Ken Ofori-Atta through the Attorney General as the central authority. The OSP reiterates that the extradition packet is not before the immigration court. The credibility or otherwise of the criminal charges against Mr. Ofori-Atta is a matter of determination by the courts in Ghana, not the immigration court, because even that packet of extradition is not before the court, so really, which have jurisdiction to determine his guilt or innocence. Such matters are not determined by an immigration court in the United States. So why did the judge venture into matters that are not before the courts? And this is where I bring in Martin Pebu, his private legal practitioner. Counsel, good evening. Thank you for joining us here on Ghana Tonight. You've been very critical of the special prosecutor regarding Ken Ofori-Atta and how he got out of the country. But taking into consideration what has happened between yesterday and today, the transcript as published, and the OSP's response, how does this get to you?
Yes, Mr. Okanse, you remember that about 2 weeks ago, a little over 2 weeks ago at least, I had mentioned on the key points that even apart from this immigration judge, I'd heard that that is the American justice system, that's the Justice Department actually, I should say, had problems with our charges, and that they were now helping us to amend the charges and to put them in a manner that conforms to the American standard. And that tells you that their standard or way of doing it, I should say their style instead of standard. Their style is not necessarily ours. So it's quite curious that the immigration judge should use the American style as a yardstick to judge ours. You see, so the first thing is that in any event, he's an immigration judge. So why would he tear so deep into the charges? I think he went a bit overboard, and it sounded like bullying our system, because I don't see why an immigration judge will go very far. Has he been asked to decide the case? That's not a case before him. So the comments went too far. It doesn't show committee. It doesn't show respect for our sovereignty. It went too far. I think he has to be called to order. It went too far. He has to understand that the world has changed. It's no longer a unipolar world where America controls everything. No, the world has since changed. There's China, there is the US, there is Iran. So it's now a multipolar world. America doesn't control everything. So he has to be guided in his comments, right? Yes, because he doesn't know tomorrow. Americans are still looking for us to extradite other persons, Daniel Yusuf, etc. Okay, we're also pushing back. So this is comments, the way it's insulting to our system, it's rather going to even cause disaffection in our system. Ghana is not America. He should realize that, and so he should be circumspect in his comments. He said, yeah, so you see that I'm being very objective. I'll not say that because I want Kisieja being removed because of his incompetence and he allowing Oforiatta to flee in the first place, etc. That would becloud my judgment, so that I would have jumped to congratulate the judge. No, I don't do my things that way. I'm being objective. I have to look at the interests of Ghana and the long-term position. It shouldn't just be so short-term that, anything that hits at Kisieja, I'll quickly say yes. No, I don't do that. We have to look at the interests of Ghana first. The way that judge is written it, no, I think he's gone overboard.
I see, and in fact, the OSP questions the jurisdiction of the immigration court in hearing this matter, because even the extradition packet is not before that court. But you have previously raised some concerns about some of the charges the OSP has leveled against the former finance minister. I mean, some of the 78 charges. You earlier raised some concerns, is it not? I mean, and I'm looking at that plus what this immigration judge is talking about regarding some of the charges.
Yes, so what I'm saying is that is the degree. So he could have done a general comment. You see, that's why I say it's the choice of words. The way he's gone and said there is no evidence of corruption, etc. We don't put evidence even in the charge sheet. We don't put evidence in the charge sheet. We state facts. We state what he did wrong. So as far as I can remember, what do you call it? The facts. Evans Oduse is a friend to Oforiatta. Oforiatta has close connections with Evans Oduse, the owner of SML. So you see that we're showing connections that Oforiatta did it for his friend. You see, personal, so when you use public office, even on the face of it, assuming Oforiatta doesn't even benefit from the money SML is making, Oforiatta has done it for his friends. So when you use public office for private gain, so you do it for your friends, for your relations, yes, that's corruption. That's corruption. So SML will be showing the relationship between SML, which is owned by Evans Oduse and his wife and other persons, and Oforiatta. So the key thing is that we don't put evidence in the charge sheet. That's not place to put evidence. Evidence is led at the trial in a witness statement. So for the immigration judge to conclude that these are conclusory statements without evidence, etc. No. And you see, we've been extraditing our citizens to them. As the immigration judge, do they bring us the evidence as we are fighting? Daniel Yusuf's family, etc. They've been saying that, but why didn't the Americans bring the evidence so that our court will also examine the evidence to determine whether it is good evidence before our courts will extradite people to the U.S. But we keep telling the families that, oh, because of that respect for each other, good faith, when they write that they have the evidence in the U.S., we believe it that they have it. So we extradite our citizens to go and face trial there. So that's how the judge is also supposed to look at the charges. He can make comments. We are not saying that he cannot say they are not good, etc. But because when he went into details, then he exposed himself. He doesn't even appreciate that in Ghana, we don't put evidence in a charge sheet. If that is how they do it in the US, well, that is their law. Their law is not universal law. So you see that he's not trained in Ghanaian law. As far as I'm concerned, that judge is not licensed to practice in Ghana. So he doesn't know how we do it in Ghana. Yeah. The only thing that, as I mentioned earlier about a little over 2 weeks ago, is because we need a furiata, then we have to kowtow to them. We have to do it according to their style to be able to bring him. But it doesn't mean that their style.
You go to Supreme Court. There should be a situation where you will put a different meaning to certain word or certain clause in a section of the law. So if it comes to say boy, and you say the boy you are seeing here is the one that has, excuse me, to say boobs. And I said, no, boy is the one that will not have boobs. Then maybe we are giving different meaning to what a boy is. Then we can go. But for the fact that anybody says that there is a constitutional issue, so let's go to the Supreme Court. The Supreme Court says, don't come to us with that. And indeed, you see, the role of the High Court judge is to apply, read the act, interpret it, and apply. And the judge is saying that this has not arisen. There is no rival meaning anywhere. And in fact, the judge is saying that you are telling us that the law that was made, the lawmaker should have rather added this word, which they didn't add. So for that reason, let's go back to Supreme Court to say that it is too broad, it is too vague. No, they just say it's very clear. There is nothing wrong about the law. You see, now, the idea, you should have, maybe because where you work, you might not have listened to some others. Yesterday in court, by all standards, Atachia said he wasn't going to be there. He sent his junior. Do you know that when the judgment was made and there was mitigation, according to people in the room, that lawyer was so shaken that when he stood up to play his plea on mitigation, the words were not coming. Another lawyer had to assist. That is the enormity of what was ahead of him to me. And you see, let's be clear here. When the prosecution finished their case, they went on submission of no case. And that was thrown out at the Court of Appeal. That says that you have something to answer as lawyers. That should tell you that the ingredients and the elements of the offense had sort of been proven. So it is now up to you to go and establish doubt in the ingredients that the prosecution has proven. So that place should tell you that 50% you are almost convicted. So you are now going to work on the other 50% to make sure that I create doubt in the mind of the trial of fact, which is the judge. So all this was going on. And in the end, you came back to say you are withdrawing. Somebody withdrew. Then somebody came up. The day of yesterday was agreed in the presence of Senior Atachia. Then on the eve of the day, you write to the judge. You see, the judges are part of society. They are human beings like yourself and myself. No matter what you take them through, they behave and think like us. And they, as such, they will behave like that. So for the last minute, for you to just pull out. And we listen to the tape right now. He said something that Chiamamun to me said, if it goes this way. So it means as at the time Chiamamun to me was entering the courtroom, he had a feeling, or they might have been aware that there's the possibility that it will go this way. But
is that not a normal thing?
It is not a normal thing. It is not a normal thing.
Are you sometimes very convinced that you'd win the case?
Yes, very
it's
convinced.
It's never a 50-50 situation?
That is why I'm saying that, you see, you would have seen what went on in court. You were in court. You had applied for record of proceedings. You have gone through. you would have subjected them to certain tests to say that reasonable person like myself, if this was said to me, does it look like one that is going to jail, or it looks like we'll be acquitted on this one? Having subjected yourself to all this. And indeed, there was a second lawyer who is attached here. So he would have seen it with a different eye to say that my colleague did this, that is good. My colleague might not have done this, that is bad.
But he had tried to even extend the judgment.
And that was given for what purpose? For what purpose?
Because he said he had taken over and needed to go through the case completely so he can make a substantial case.
No, that time the case has ended. The only thing he needed to do was written submission. Okay, that was the only thing he needed to do. And the judge has indicated that the written submission largely will not sway where her thinking will go. So what was it for? So in effect, I am advising the MPP guys this morning that go. The ruling, the judgment is all over the place. Pick it. Take your time. Go through, read one by one. Even if you are not a lawyer, ask a lawyer's view on it. An unbiased view. You come to one irresistible conclusion.
Which is what?
The appeal will even fail. Worse than what they got in high court.
You think it will fail? Okay. Well, I'll come to you shortly, Councillor Nuku. I'll come to you. But also joining us via Zoom this morning is Awula Sewa. She's a coordinator for eco-conscious citizens. It's a CSO that's been very vocal on Galamsey activities in this country. For the longest time, of course, they had been calling for, especially the main people behind Galamsey in this country to be arrested, prosecuted, and jailed. And so, as at yesterday, she didn't indicate that Wontumi's conviction to her was a step in the right direction. Let's get her thoughts on this further before we come back into the studio. Good morning, Awula Sewa.
Good morning to
Thank you
and
for
your
joining.
viewers. Thank you for having me.
I hope you're doing well.
By God's grace.
Well, I'm sure you've heard the MPP's General Secretary, flanked by some leaders of the party yesterday, indicating that, there was no evidence that was adduced in court yesterday, enough to have Wontumi sentenced to 20 years in jail. And that's the judge most likely, of course, clearly focused more on circumstantial evidence. And for them, that was not enough. And so as it stands now, they describe Wontumi as a political prisoner. You say this conviction was a step in the right direction. How do you juxtapose the two statements from yourself and the MPP?
Well, what I would say is that there was a lot of evidence. I'm struggling to see where the NPP is coming from. The judge is an appeal court judge sitting as a high court judge. Be that as it may, our legal system allows them to appeal.
So I'm told that she's not an appeal court judge, by the way. So she's just a high court judge.
Right. I have been mistaken. I stand corrected. Thank you for the correction.
Thank you.
Be that as it may, the judge found otherwise. The judge believed there was sufficient evidence to support a conviction. The legal system allows anybody who is dissatisfied to appeal. So they are welcome to appeal to the Court of Appeal. If they are still dissatisfied, they can go right up to the Supreme Court. But for me, the message that it is sending is that if you are involved in illegal mining, if you are destroying our environment and poisoning our water bodies, it doesn't matter how well connected you are, you will eventually be held accountable. And I have to add that we cannot stop with Chairman Wontumi. He cannot be the poster boy for illegal mining. Everybody, rich, powerful, anybody who is involved in illegal mining, whether within the last administration or the current administration, should be held accountable. It should not be selective. And I'm confident that this is just the beginning.
We in small do a team course or channel so not so Jim Rewa. I send us what in the Dumbia.